Welcome to this recording of the Activist Lawyer podcast, brought to you from the Granite Exchange studio in the heart of Newry. We are delighted that you could join us today for another episode of Activist Lawyer, where we will be engaging not only with lawyers, but people who are committed to highlighting and combating injustices and inequalities. We will bring you our thoughts and invite you to share yours. We'll be looking for contributors to our blog at www.activistlawyer.com. So today I am joined by fellow immigration practitioner Carol Sinnott. I'm delighted to have Carol speak to us on a topic that I'm familiar with, but one that will be of interest to many of our listeners for several reasons. Just to provide a little bit of background, Carol Sinnott is an immigration solicitor and principal of Sinnott Solicitors in Dublin and Cork. I think you've recently opened an office in Cork as well. And she has extensive experience in dealing with immigration and asylum and started working in the area in 1999 before qualifying as a solicitor in 2004. Carol started her career with Cathal O'Neill Solicitors, who started the very first immigration law firm in Ireland. Her firm has been involved in many high-profile immigration cases, some of which have shaped Irish immigration law and made their way to the European Court of Justice. Very, very good. So, Carol, thank you so much for joining us today. It's great to have you.
Thanks, Sarah.
So, Carol has been in our offices before. She's been in our studio. But today, with restrictions and everything in place, we are having a chat across the border via phone in. So hopefully the sound is okay for everybody. So this is a first for us. But I think given that restrictions here have been extended, it might be more of a frequent occurrence. So Carol, just in the introduction there, I'm familiar with the area of practice in your jurisdiction as well as here. So you've got, I suppose, vast experience covering all matters relating to immigration. And you've recently expanded your firm. I think, was it a couple of weeks ago you've opened your new office in Cork?
Yeah, so just before Christmas, we opened our Cork office. So that was a very exciting development for us.
Absolutely.
And so there are two solicitors there, Una O'Brien and Louise Ring, who are heading up the operation down there. And we're delighted about it because over the last few years, we've had a lot more clients in the Munster region and obviously nationwide because we're immigration solicitors. And I think it will definitely help us to expand operations. But other than that, I think it will make it a very convenient location for a lot of our existing clients as well.
Absolutely, because I remember starting off in immigration many, many years ago, and most practices were based centrally in Dublin, but you'd have clients from all over Ireland, and as you said, it will be convenient, because people have different needs. Accessibility can always be an issue, so that's fantastic that you'll be serving that region. And just, you've opened up expanded during a pandemic. How has the current restrictions and COVID impacted your practice in general, or has it? Have you been managing okay?
Well, I find that the third wave is very different to the first wave because last March, everything more or less stopped for solicitors across the country. Mm-hmm. And, we are in many respects essential services, but, with people being at home and working from home and the fact that the immigration wasn't as, people weren't coming into the country as much. I guess that probably slowed things a little, but certainly I find that in this third wave, we're very, very busy with immigration, whether it's sort of work permits, renewals, visas, it doesn't stop really.
It doesn't stop. It continues. Yeah. And people are more used to the fact.
Thankfully.
Yeah, it's great. And I suppose you just learn to manage and, you come up with new and creative ways to deal with your clients. And I think clients are very respectful of the fact, that changes had to be made, etc. But I agree with you that the first time was complete lockdown and even trying to get documents sworn, you had to figure out, well, how am I going to submit this application if I can't get another slip? So kind of practical things arose. Whereas this time, I think most people have figured out a way to make things work and we're getting used to it. So long may it continue that.
Completely different.
Exactly. Yeah. So just to move on to some of the key issues that we're going to look at, and it's really one topic in particular, and I'm so keen to chat to Carol about this because it's quite a live issue for us at the moment, and people making inquiries, I suppose, across Ireland with various immigration practitioners around Irish citizenship and the Irish passport. So a recent article had said that it's obviously becoming somewhat of a very important commodity of late, ranking 6th most sought after passport in the world. So with us, I mean, the obvious thing to point at in our region is probably Brexit, and we can relay some of the growth in the increase in demand for the Irish passport to Brexit. Certainly for us, you'd have clients who would say, previously, we may have considered applying for the British passport if they're living in Northern Ireland and meet all the residency criteria, but now they're interested in looking at the Irish passport and seeing what it offers them. So we've experienced an increase in queries there. And I guess in general, it's good to go through naturalisation, and many people won't really be familiar with the process, and it can be somewhat complex, Carol. So it's great to have you here. So firstly, we're going to just provide a little bit of expert insight into actually applying for citizenship through naturalisation. So we're not talking about applying for an Irish passport as such. It's more so how people can look at becoming Irish mostly through naturalisation, a process that Carol will go into. So perhaps we can have a look at the concept, Carol, of Irish citizenship and what's involved maybe for our listeners.
Yeah. Well, Irish citizenship, it can be acquired in a number of different ways under the Irish Nationality and Citizenship Act. Naturalisation, obviously, is one of those ways, and one that you'll certainly be familiar with, Sarah, as are we, is the joining the Foreign Birth Register,
yes,
whereby citizenship by descent, and a third way then is citizenship by association. So I guess the last couple of years, for us anyway, I don't think in my lifetime we have ever made so many applications for foreign birth registrations, mainly because of Brexit, so anybody with an Irish grandparent or whatever, everybody wants an Irish passport, whether they're in the UK and other countries as well. Mm-hmm. But once that sort of fizzles out, I think it's fair to say that the largest number of citizenship applications are through the process of naturalisation. Mm-hmm. And that is the process by which the state may confer Irish citizenship upon a person as a privilege, not a right. And that's led to the most significant rise in applications for citizenship. So there's other factors as well. For example, the Trump administration, a lot of US citizens wanted an escape route and an Irish passport if that became necessary as well. So we would have had a lot of those types of applications over the last few years. Mm-hmm. But obviously the conferral of Irish citizenship has so many benefits, not just the fact that the person becomes an Irish citizen, but it's also the gateway now into Europe, and the fact that those people will derive so many benefits from the EU directives for free movement of persons and all of that.
Absolutely. And even now we're seeing kind of post-Brexit, the new era that we're in here currently in Northern Ireland. I suppose there's a temporary opening of rights afforded to third family members of Irish citizens who live in Northern Ireland who also, possess an Irish passport. That'll soon come to an end, no doubt. But the questions that arise are, well, what rights would I have if I use my Irish passport and relocated to another EU member state? And of course, they're probably still able to rely on, the EU directives and free movement, as you said, whereby somebody solely relying on a British passport won't be able to access that any longer. So yes, there's many benefits. And I guess your firm in particular, I've seen quite a few articles of late and some important immigration judicial reviews that you were involved in were before the High Court in Dublin. So I think practitioners have followed with great interest, not just your cases, but recent developments in citizenship case law in Ireland, Carol. So you might just comment on some of those significant challenges that we've seen of late.
Yeah, well, once the decision to refuse an application for naturalisation is made, there is no right of appeal. Mm-hmm. And that means that the only way of challenging a refusal is by way of an application for judicial review before the High Court, which is why there has been so many judicial reviews in relation to citizenship applications. Mm-hmm. So there has been definitely some very significant constitutional cases regarding citizenship in the last few years, and in particular to do with refusals regarding refusals for reasons of character of the applicant, failure of the applicant to meet the residency requirements, and obviously the area of revocation of citizenship has also become very prominent in case law over the last few years as well.
Yeah.
So,
and we've seen a bit of a change, I suppose, in the court's attitude as well of late, just towards certain applications. I think you were involved in one of the cases around the 6-week absence rule that we'll talk about a little bit further into the conversation. But you do see a bit of a shift, and I suppose a little bit, as a result of that, a bit more pressure perhaps on the government to review potentially the way citizenship is handled in certain regards. And just from reviewing other countries and really digging into the application form itself, Ireland has, I suppose every country has its own unique interpretations and their own policy and legislation around what it means, because at the start you did say it's a privilege, not a right. So it's therefore quite a discretionary type of application. But some countries are less restrictive. I know Britain in some respects is in the UK for people applying for citizenship. But we might look at, I suppose in a general way, more specifically those cases around, even the duty of the minister. I remember being a big feature. The minister would never provide a reason in some cases as to why it was refused. So that was challenged in a very important Supreme Court case.
Yeah, so there is a long history of case law in relation to citizenship. But so, for example, before 2012, citizenship is discretionary, and that's just it. It's a privilege, not a right. So there's no automatic entitlement to it, and the minister has an incredibly wide discretion, or certainly had. But so before 2012, there was a Supreme Court case of Malik and the Minister for Justice, and that case established that the minister must provide an applicant with reasons for refusal, or at the very least to provide the justification for not providing reasons. And the situation before Malik was that the minister didn't need to provide any reasons whatsoever, or any reasons for the refusal to provide a reason. So it was a very, very uncharted territory up to that point. And since the Malik decision, there is a much bigger onus now on the minister to provide not just the reasons for the refusal, but also the rationale for those reasons in coming to decisions for, in refusing applications based on character and residency and deciding to revoke applications,
Absolutely. So it's an area that's really evolving slowly but surely, because that was only 2012, not so long ago that factor changed. Another matter that crops up, I spoke to you about it a little bit before, I'm dealing with it at the moment, concerns refusals based upon, this good character requirement. And I think the notion of good character can be quite contentious when it comes to applications for Irish naturalisation, and also very confusing for some applicants when they're actually, completing their form, and it's something that gives them, great concern in many cases. So I know you've some experience in this yourself, Carol, with some of your cases and just looking at recent case law in general.
Yeah, so in order to meet the criteria, the applicant has to be of good character, and that's the statutory basis for that is Section 15 of the Act. The minister is obliged now, because it has been established by the Supreme Court and the Court of Appeal that the minister must provide a proper rationale as to why the character was called into question. And indeed, if the applicant is ultimately refused, the rationale has to be quite specific. So there was a recent Court of Appeal case in 2020, the case of MNN and the Minister for Justice. And just to give you an example of this, Sarah, in that particular case, the minister had made a decision without putting the incident and the subsequent strikeout order in its proper context. So it concerned a case whereby 2 road traffic offences and another alleged incident led to a decision that the applicant had failed to meet the good character requirement.
Mm-hmm.
And the court in that case noticed that it was clear that the court it couldn't decipher what view the minister took of the alleged offence, but it was also clear that the minister must have taken some view, because otherwise there would have been no need to refer to the incident in coming to his decision.
Mm-hmm.
And in that particular decision, the court ordered that the minister's decision be quashed and that the applicant's application would be readmitted.
Yeah.
And then, not too long after that, there was another case called Tala and the Minister for Justice. And in that case, again, the minister wasn't satisfied of his good character, and the decision referred to the applicant as having a history of non-compliance of laws with the state. But the Court of Appeal in that case wasn't satisfied at all that the minister had considered and weighed up all of the relevant considerations, including the man's explanation for his motoring offences.
Mm-hmm.
And the court held in that case that the minister had failed to express his rationales for deciding that the nature of the offences meant that the applicant was not a person of good character. So it sets the standard for the minister now to provide the reasons and the rationale for coming to that decision.
Yeah, which is only fair, and it's good that it was kind of reviewed on a case by case basis almost, because I think the solicitors in that case in particular had, submitted reasonable explanations, and it was very, very clear. So that was a very positive outcome, and it's just good in a sense just to see how decisions are reached and how the court took that view. Another thing that comes up, of course, is in the application form itself, what to disclose and what not to disclose. So again, there can be some ambiguity around that, and people may be surprised then if their application was refused for not disclosing something. And really the position is around convictions, I guess, is the most important word that kind of strikes you when you look at the application form. But have you come across that issue? I know I come across it all the time. Carol, I'm sure with your clients, and what you should disclose and what's relevant, etc.
Well, actually, that case that I've just spoken to you about there, Tala and the minister, in that particular case, it was interesting because the court said in that case that the citizenship applicant must disclose previous convictions, even if they're spent convictions, right? So that's extremely important, because a lot of applicants mistakenly believe that spent convictions are not of any relevance to their application. Mm-hmm. And so a certain number of convictions become spent after 7 years.
Yes.
For example, convictions in the district court for, say, motoring offences, apart from, say, convictions for dangerous driving, which are limited to a single conviction, and then convictions for minor public order offences and certain other convictions, after 7 years, they become spent. Mm-hmm. But if an applicant is making an application for citizenship, well, then they must disclose all of those spent convictions as well.
Yeah, it's so important. And I guess that's where some confusion arises, but I think that's a point that really has to be taken on board for anybody making an application. So, and obviously that feeds into a decision around good character. And it is something that comes up here, just in terms of just the logistical side of things. The minister, in all cases, as an application progresses, will ask for a criminal record check. And in Northern Ireland, that's done through the DAT1 form as accessed through the PSNI. So that comes at a later stage after submitting an application, but people should still be aware, as you said, although a record may not show spent convictions, it should still be disclosed. So that's very important. So something I've rarely come across, Carol, and I'm wondering if it's something you've encountered or you've been following any case law on it, is again looking at reasons for refusal, something that crops up around national security concerns. I'm wondering what your thoughts are on that, because I think there's been a few recent cases around refusals that have been growing on this point in recent years.
Yeah, there has been a growing number of refusals in relation to national security concerns in recent years. just in May 2019, the Supreme Court ruled in a case called AP and the Minister for Justice. And in that case, you see, national security is such obviously an important thing that, the minister seems to have a wide discretion in refusing applications on that basis. But in that particular case, the minister didn't provide any reasons for the refusal because the minister relied on certain provisions of the Freedom of Information Act as for the reasons as to why the applicant's rights to know the content of the materials relied on weren't available. And the minister argued in that case that the applicant's rights in that regard were outweighed by national security considerations. And that the minister said that, the minister needed to maintain the confidentiality over the information concerned. And that argument, interestingly, was upheld in the High Court and subsequently in the Court of Appeal until the case went to the Supreme Court. And the Supreme Court said in that case that the ultimate decision on whether the state's interests outweigh the requirement to provide that information is a decision that must be made by the court and not by a state authority. So it was an interesting judgment in that the court held that the failure to give the more detailed reasons can only be regarded as justified if that failure impairs the entitlement to reasons to the minimum extent necessary. So in that case, the court said that the state didn't abide by the principles of proportionality in impacting the rights of the applicant to the minimum extent. So, and just on national security concerns, in October last year, the Minister for Justice, Helen McEntee, she announced the establishment of a single-person committee of inquiry, which is new, and that will be served by a retired High Court Judge, John Hedigan. And I understand that committee is being established to review, upon request from the applicant, the materials upon which the decision to refuse the certificate of naturalisation was made. So that will be another, I guess, interesting development in terms of national security concerns.
This podcast is sponsored by Granite Exchange. Do you need an office or a meeting room space? Granite Exchange is the ultimate serviced office and meeting room facility. Located in the heart of Newry City, it is perfectly placed between Belfast and Dublin. Each office suite is fully furnished and comes with an all-inclusive monthly fee with no long-term contract. All you have to do is show up and switch on. The rest is taken care of. For more information, call 028 3044 2500 or visit www.granite-exchange.com.
It seems to be an area, I know it's its own area in terms of just naturalisation as part of the whole wider immigration process, but it certainly seems to be grabbing attention at the moment, with, as you said, this committee of inquiry and then the recent surge in High Court decisions as well are really shaping citizenship going forward. Just to maybe finish on the point around refusals, another issue that crops up, and I'm sure for you as well, not just around the good character, but is the point around continuous residency. And this can be confusing for clients or for applicants, but there was recent case law on this point as well around, the 6-week rule and how people actually show that. So just to give some insight around that, Carol, and your experience in those cases, because I know I've plenty going on at the moment around it.
Yeah, well, I think it's probably an area that's not just confusing for the applicants, but it can confuse the solicitors dealing with the applications just as much. That's what we call the 6-week rule. And it's a rule that kind of crept in over time with no statutory basis for it. And I think we can kind of pinpoint around mid-2018 or so that sort of crept in as a policy consideration almost. And but anyway, the Citizenship Act states that one of the conditions of naturalisation is that the applicant must have had 1 year's continuous residence in the year prior to the date of making the application, right? That's on top of the fact that the applicant must have 5 years out of the previous 9 and 60 months reckonable residency and all that kind of stuff. But the year in which prior to the application, the applicant must have been continuously resident. And that case was, that rule, the 6-week rule, was challenged in 2019 by, we were involved in that case, and it's the Roderick Jones case, Roderick Jones and the Minister for Justice, and that case, I guess, provides some clarity now around that 6-week rule. In that particular case, the applicant challenged the 6-week rule as his application had been refused on that basis before the High Court. And the High Court decision effectively said that held that there wasn't, in fact, any basis for the rule, lawful basis, but at the same time that continuous residency required the presence of a person uninterrupted residence, which meant that effectively after that decision we were sort of left in a situation whereby it was interpreted that the applicant couldn't even be out of the country for one day.
People were given crazy examples. Could you cross the border to Newry, to do your shopping for the day and stay over? So you were hearing these different scenarios crop up and listening to solicitors being interviewed. It was just and to look at that decision literally, that's kind of what it meant. Like where it did. To be fair, the court did say that there wasn't a basis for it, but at the same time, the interpretation that the court gave of continuous residency caused a lot of confusion for a long time, until the Court of Appeal overturned that continuous residence finding of the High Court. And the Court of Appeal actually found that the policy of the minister wasn't a rigid or inflexible policy, and that the policy was reasonable, right? So the upshot of that Court of Appeal decision, whilst it does provide significant clarity on the law, and we're more or less stuck with the 6-week rule, the difficulty for us now is that we don't have any clarity on what exactly the rule means, because we need further clarity particularly in relation to the 6 weeks absence policy and what exceptional circumstances and work related travel are allowed, for example. So, I think it would be good to get more clarity on what is considered to be an acceptable absence and what is not. So the judgment really just takes us back to the position pre-July 2019, where absences of up to 6 weeks were permitted, but we have no guideline related to work or allowable absences in exceptional circumstances. It's still confusing, and sometimes it's difficult for clients to even track, for applicants to track how long they have spent, depending on whether it was work related or visiting family abroad, which is common. I mean, we live in a global environment, and it's quite normal that people would spend, lengths of time out of the country, but it doesn't affect their residency because that's still where they're based, and so it does cause confusion. So I think you're right. More reform and more clarity needed around that point. So for me, I guess the main strands of applying for citizenship that come to us in terms of queries, and I suppose are very visible there through the case law and the various examples that you set out, Carol. But just in terms of, this has been on the increase too, I think, the issue of revocation, and the Act does provide the minister with a power to revoke a certificate of naturalisation. Have you any experience in that area, and what are the important factors for listeners to know about that?
Yeah, we certainly have. In the last few years, we noticed that the revocation of citizenship has become a very big thing, and it's quite a common decision now for the minister to revoke citizenship. and often in circumstances where the applicant may have had citizenship for a number of years. So once the revocation order is made, it unravels so many things for the applicant. Like it obviously unravels once they're no longer citizens, it affects their lawful residence in the state. If that filters down to their families, and it's a devastating blow really for applicants when their citizenship is revoked. And but the minister has the power under Section 19 of the Act to revoke citizenship for a number of reasons, and all I would think very valid reasons. But there has been some recent case law as well in relation to that. Issue, I think I should probably point out to you there at the outset that one of the most significant judgments is the case of Ali Damash, which was that particular case came before the Supreme Court last October. And it concerned an Irish citizen who was serving a sentence in the US after pleading guilty to having conspired to materially assist the terrorist group. And in that case, the Supreme Court in that case concluded that because of the drastic consequences of a revocation of naturalisation, that a very high standard of justice must apply. And it held that the process provided for in Section 19 of the Act didn't actually provide the procedural safeguards required to meet the high standards of natural justice applicable. So, in particular, an applicant must be entitled to a process which provides minimum procedural safeguards, including an independent and impartial decision maker. I'm quoting there from the judgment. And the Supreme Court held that Section 19, which sets out the power of the minister to revoke a certificate of naturalisation, is in fact unconstitutional.
Yes.
So it will be interesting to see what the upshot of that case will be, and what how that will be remedied.
Absolutely. So really we've touched on the important aspects there, including revocation, which is really an interesting area. So that's one to watch. And, obviously you're noticing the surge in applications from around the world for many, many reasons that we spoke about earlier. But just to kind of, I suppose, relate back to this podcast and the title of this podcast, which is, of course, Activist Lawyers. And, we've been very lucky to have fantastic guests join us on this new podcast. It's only started towards the end of last year. So with your area as well, Carol, and I know you've worked in, we're talking about citizenship today, but you've really covered a broad range of immigration matters throughout your career, including asylum and, people who are in very, very vulnerable positions. But looking at citizenship as well, I suppose in the context, and we'll just touch on this, we've spoken about it a little bit previously, just around, I suppose, the concept of Irish citizenship and how one attains Irish citizenship after the referendum in 2004, and how that changed the whole context in terms of children who are born in Ireland, and how, if they're born to non-Irish parents, they would no longer have the automatic right to Irish citizenship unless at least one of those parents had lived here for 3 out of the previous 4 years. And people still ask us those questions, if they're unsure about the law, and they'll say, look, I have a child born in Ireland, when you're looking at their status to see what it is. So there's been a lot of discussion recently, I suppose over the last few years, about the 2004 referendum, and a poll was put out, I think the Irish Times did it not so long ago, where the figures changed. And I think it was a close enough call, but the figures had changed in terms of people looking at maybe revising this area, whether through, another referendum or through whatever means possible, to give children a right to citizenship who were born here. How have you been? Have you been following any of that, or what's your thoughts on that? This was the legislative process involved.
At the moment, there is a bill before the Seanad, and I think it's at the third stage at the moment. the Irish Nationality and Citizenship Naturalisation of Minors Born in Ireland Bill 2018. And that was put forward by the Labour Party and sort of heavily backed by Ivana Bacik, Aidan O'Riordan and Kevin Humphreys. And effectively, the bill, if the bill is passed, it would amend the law in Ireland in relation to applicants for a certificate of naturalisation by minors born in Ireland. My understanding is that if they've been here for 3 years, that if the bill is passed, well, just on a very general level, I think that the minor children would be entitled to citizenship having resided here for 3 years. And but that bill is very much at an early stage. I mean, it is at the third stage, but whether that bill will become law is another matter.
Remains to be seen. Yeah,
it would certainly be a very welcome development.
Absolutely, it's just how we get there.
It's just how we get there, and it's really, people are in very difficult circumstances. Like, I mean, you could have children that, for example, of school-going age, about to do the leaving certificate or something like that. And even though they're here in the Irish system and they get the points in the leaving cert and all that kind of stuff, if they're non-EEA national, the college fees are so penal that they're just, they can't continue with their education. Yeah. So I think, if we are, if there are children born here and make their lives here and they're here for a number of years and they go through the system the same as an Irish citizen child, well then this act would be a very welcome development.
Yeah, and I mean, there was lots of high-profile cases in the media where you would see communities in Ireland rallying around families supporting particular children's cases as examples. And I remember the former Minister for Health, Simon Harris, backing cases within his own constituency at the time. So, Ireland's a small enough place and I suppose communities are, to a large extent integrated. So I can see where the support would come from when people, especially young children, are really, really part of their community. They're born here. And I suppose that's in contrast to people who apply for citizenship through, for example, the Foreign Birth Register from abroad without maybe ever having been in Ireland. So there's lots to discuss there. But I think I agree with you, Carol. It would be a very welcome development, obviously. Just another, I suppose, related point that we've been looking at in terms of the COVID and the pandemic and, great changes around immigration in the UK as a result of Brexit. And I suppose the catalyst has been COVID and putting things together. But frontline workers in many EU countries, the last I looked at was France, offering to expedite applications for citizenship. Where do we stand in terms of that in Ireland and Irish citizenship, do you think, or has there been any movement around that concept?
I guess there's two points there. The first one is that only last week the minister brought about, because of COVID, obviously people couldn't travel to the ceremonies to give their declaration of loyalty to the state and all of that, which meant that we were left in this sort of really unfair situation whereby many people had already been granted their certificates of naturalisation or had been approved for them but couldn't turn up to the ceremonies to actually make their sworn declaration to the state and thereby obtain their certificates. So since last March, there were, I think, 4,000 people affected by that. And the minister just last week, she is now sending those people a declaration, an affidavit effectively, a declaration of loyalty to the state, that they can sign that declaration and therefore get their certificates of naturalisation unaffected by COVID.
Great.
So that's one issue. But just in relation to just going back to that, there will be a lot of healthcare workers probably in that 4,000,
yes, of course.
But there are thousands and thousands of citizenship applications that have been delayed considerably, not just because of COVID, but because of delays in the system. And there are a lot of healthcare workers, doctors, nurses, whatever, that are waiting on their applications to be dealt with for a number of years. Now, my understanding of that is that has an effect on their training their job opportunities. It puts them in a situation whereby they have to continually renew residence permissions where they already fit the criteria for citizenship and have made their application. So only this morning, actually, I came off the phone from a doctor who has been waiting now for 4 years almost for his citizenship application to be dealt with. And that's not that uncommon. I know 4 years probably on the higher side, but at the same time, there are thousands, not just healthcare workers, but people who are waiting for their citizenship applications to be dealt with for well in excess of 2 years.
Yeah.
And I think because of COVID now and all of that time period will go up and up and up. And it's completely, in my view, unjustified to keep somebody waiting for that long in circumstances where they already fulfill the criteria, because we don't have a system to, not even a system to accelerate people, but just an efficient system that will, process and get these applications in a timely manner.
Yeah, absolutely. And you meet with clients, it's so frustrating. I mean, for them, it impacts them. As you said, you've given examples there at how it might impact somebody. We have, I think the longest we have is just over 3 years. But that person, they're very anxious about it. And, they'd say, could you check, have they got the application, which they have because it's been acknowledged, but, has it fallen off the radar? Is it still being looked at? So you can imagine yourself the stress and anxiety that goes along with that. And it's not justified. So I think the microscope is on citizenship and in general. And it's great that we got to discuss the development in case law around it, which is highly important. But also just some of these issues have been ongoing pre-COVID, as you rightly point out. And I think there really needs to be a whole review, particularly in terms of the delay. And only this week there was articles published again about the extortionate delays in Irish citizenship. So just before we finish up on the citizenship point and finish off today's episode, it strikes me that another issue, I suppose it's a worldwide issue that has arisen, and I've recently been seeing it from emanating from American US press around Biden and the call on the new government to do something around undocumented migrants there too. Ireland is making some moves around that in terms of the 17,000. It reports 17,000 undocumented migrants who are basically living in limbo. And there seems to be some movement to consider a new scheme. What do you know around that, Carol? And, is there any useful information for listeners around that?
Yeah, well, I certainly hope that is the case. The Minister has indicated that she will accept or put in place a scheme for undocumented migrants living in Ireland, which, if that is put in place, that will be the biggest thing to ever happen in the history of Irish immigration law. Now, I read some of the articles as well, and I think it's estimated that there are 17,000 undocumented migrants in Ireland. I believe that the figure is far higher than that. I don't have any basis for that belief, but I guess I'm just thinking about the number of people that we see here, even on a daily basis, the number of inquiries that we get from undocumented migrants. And since the Minister has published this, given out some indication that there will be a scheme in place, and I think the indications are that it might be put in place early in the new year, the inquiries have just spiraled through the roof here. People, that have been here for sometimes like 15, 20 years, and they're living under the radar. And, I think if those people could be helped, and if their immigration status could be regularised, and many of those people would be of enormous benefit to the state.
Absolutely. And a lot of them are children included in the figures, wouldn't it be?
Yeah.
So undocumented children, yeah.
I have to say, Sarah, in all the years that I've been doing this, I've never come across an undocumented migrant that wasn't willing to work, contribute to the state.
Absolutely.
And, every single one of them, almost without exception, they work, and they pay taxes to the state, and they do contribute to the state. And then many of them obviously are probably not working by paying taxes to the state, by doing it illegally. And but not that those people working are entitled to work as such. But you know what I mean? There are people paying taxes to the state. They're in a lot of jobs. But I think if those people were allowed to stay, I can't see how the state would
be negatively
not
impacted.
Benefit
yes, exactly.
Yeah, and it's just heartbreaking, really, to see people coming in here that have literally been here for years, living under the radar. They're afraid they can't go home to a family funeral or a bereavement. Their parents might die, their siblings might die. They're absolutely effectively trapped here.
It really is. It's devastating.
It's very heartbreaking.
It really is. And as you said, I mean, my previous experience in Dublin, when I worked there, you did encounter so many people. And it was even a fear of speaking to an immigration lawyer about their case and giving away too many details. There was a real trust issue there about speaking to anybody. But COVID really highlighted that, didn't it? In terms of even people afraid to report for testing. And the government had put some kind of campaign in place around, look, go and get tested. If you have symptoms, please attend, your local GP or whatever it might be. So really that recognised, we're all aware of it, but put it out there to the public that people are undocumented. They're living among us in our communities, working away, and, COVID affected everybody, no matter who you are. So the recognition was there. And I guess perhaps that has spurred this more concrete development, as you said, one of the biggest developments in Irish immigration in a long time. But perhaps that really highlighted it. And obviously the need for more workers in, healthcare, care workers, all of that these people could contribute to and perhaps already do. So really, really important, and it's really exciting to see how that develops. So interesting times, Carol, in immigration in general for all of us. And of course, we just previously mentioned our activist lawyer podcast here, and what really, I suppose, it came from the government, the UK's government's attack on immigration lawyers. Were the first to be sought after around, calling them lefty lawyers and do-gooders, etc. Just for our listeners or anybody interested in getting into this area, maybe in particular your area of work, what would you say to them, and how important is it to continue with activism within your area?
Well, I think that being an immigration lawyer is, firstly, the work is extremely rewarding. It's interesting. There's so much law in the area, and it's very exciting. There's the High Court challenges and constitutional elements to it, and certain cases change the law and all of that. So I think as a career for a lawyer, it's probably a very exciting one, because you're getting so much, I suppose it's a very humanitarian role, but at the same time, it's, you get involved in very significant cases even before the European Court. So that's one area I think that a lot of other areas of law wouldn't have.
Exactly.
And just in general, I guess it's a problem in the UK as well as it is in Ireland. But in the UK, I know that migration consultants are regulated, and it's a regulated function. But in Ireland, unfortunately, there is no regulation for migration consultants. So effectively, anybody could call themselves a migration consultant and start to provide that type of service without any experience whatsoever. And unfortunately, a lot of vulnerable people fall prey to those types of individuals. And so I guess thankfully the Department of Justice in Ireland only deal with immigration solicitors in relation to, in other words, what I mean by that is all of the correspondence in relation to cases and that come to the solicitors. And they don't deal with migration consultants. But we definitely need to regulate that area, because there's a number of immigration lawyers, not that many in Ireland, and they're all trying to do a good job and trying to run their practices very well in the area of immigration. But unfortunately, we are hindered by migration, or so-called migration consultants. I'm not tarring them all with the one brush, but there are certainly a number of them out there who don't put the clients first, and who, as far as I can see, take significant advantage of them.
Yeah, and many of these clients, as you say, are in completely vulnerable positions and, are easily targeted. And I guess it's good that even the Law Society in Ireland, as recently as today, I think, have highlighted some practices as well. So, to have that more of a regulatory system in place would be crucial, I guess, given the extent of that type of practice. But again, I suppose access to justice is the main thing here, and to really play that down, as the government in the UK has done, is just really flies in the face of the rule of law. And so the work that you're doing, and I suppose your team behind you, Carol, is just so important and so valuable. So I think on that note, I think we'll finish up today, and I'd like to thank you for taking time out of your very busy schedule to talk to us here. And Carol will hopefully be in touch again around further developments, because it's such an interesting area of citizenship and some of the other areas you work in immigration. So thank you for joining us today.
Yeah, thanks very much for having me, Sarah.
No problem at all. So for listeners, you can tune in to our podcast and our blog as well on www.activistlawyer.com. And we look forward to next week's episode. Thank you for joining us. Bye.
This podcast was recorded in Granite Podcast Studio. Interested in starting up your own podcast but don't know how? Granite Podcast Studio can help. Record your podcast in our state-of-the-art studio, which is based in the heart of Newry City. Our studio has cutting-edge and user-friendly technology and can seat up to 4 people. We also provide an editing service for our team, using your guidance and editing notes to provide you with a flawless finished product, leaving your listeners wanting more. For more information on how you can get started, visit www.granitepodcaststudio.com.